All rise.
Okay, go ahead and have a seat. Good morning. Let's get the record on here.
Give it 1 second.
Okay, so case number 2024 CR 1974/1, State of Ohio versus Michael Foley. The matter is set for hearing argument on defendant's motion that was filed on the 17th asking to withdraw the plea. Mr. Ryan, Ms. Jackson here on behalf of the defense. Mr. Anchor's here, Special Assistant Prosecuting Attorney from the State Auditor's Office. The motion gave us a little bit of detail, but not much facts. So I'm going to let the lawyers argue that, and we'll kind of work our way through it. And my apologies while I worked another case through while everybody's sitting out here waiting. So my apologies for that. But Mr. Ryan, it's your motion, so you and Ms. Jackson can go ahead.
The basis of the motion deals with really the essence of the agreement and the issue of collateral consequences. I think it was clear during the plea of no contest to the 2 charges that the issue of collateral consequences was dealt with. There's competing statutes that have come to our attention that, if interpreted one way, would lead to collateral consequences that were not intended by the parties. And that's the State of Ohio and the defense. And I think there's an agreement on this, and that was sort of the meeting of the minds. The issue as it relates to this case is that the plea agreement that was struck in this case, it was intended that the consequences be limited to those issued by this court, and Mr. Foley's standing as Clerk of Courts would not be affected by the plea, the sentence, or any collateral consequence of that plea or sentence. I think that's what the meeting of the minds was. There's a statute or a series of statutes that seem to be in conflict with each other, and based on that conflict, we at this point think that it is prudent and really would be a manifest injustice and a breach of the meeting of the minds, the contract, if you will, or of the plea agreement, if it was not to be withdrawn. That's our argument. If the court needs more by way of fact, I think I can throw it, make a record as to that. But those are the concerns, and I think the statutes as it relates to 296101 and 296102 are very clearly in opposition to each other, and I don't think the Supreme Court or any district court has ruled on that at this time.
Thank you, Mr. Ryan. Do you want to add anything, Ms. Jackson?
No, at this time, Your Honor. Thank you.
Mr. Anchor, go ahead.
Judge, motions to withdraw pleas are routinely granted. Difficult for me to find a basis for an opposition, so I don't have an opposition to the motion being withdrawn. I can, on a good faith basis, argue against Mr. Ryan's arguments or his motion. So I don't have much to add there. I think we'll take some statutory analysis and maybe some case law analysis to see if we can navigate the challenges the legislature has put before us to bring this to a resolution if we're going to. Thank you.
What's the prejudice, Mr. Ryan? You have to demonstrate prejudice.
Prejudice would be extreme in this case, Your Honor.
Don't articulate.
The prejudice in this case that if the court were not to allow us to withdraw the plea, that Mr. Foley could face collateral consequences that would drastically affect his career.
Yeah, but we don't know the collateral consequences. So is it the fact he faces them, or does there have to be actual consequences?
Well, if we wait for the bomb to explode and then look backwards to see the consequence, it'd be too late, I guess, to fix the problem. At this point, I think it's pretty obvious that the statute that we intended to be dispositive of the issue may not be the statute that's dispositive of the issue. And I think that there was a clear meeting of the minds that one statute was the one that was supposed to apply, and it seems clear now that that may not be the case. And so given that, I think there would be, if we were not to withdraw the plea now and we were to wait for the consequences to arise, then we would be in a place where we would not be able to put the defendant back in a place where he was prior to that. In other words, the harm done would be unfixable at that point.
I don't disagree with everything you said, but we need a good record, because you have to demonstrate actual prejudice to set aside a plea post-sentencing. Ms. Jackson?
Your Honor, in regards to the prejudice, I think it's already commenced. There has been a petition to remove Mr. Foley from being the Clerk of Courts, which was the collateral consequence that was specifically spoke to during the plea colloquy between the state and defense counsel, as being an intended term, a material term of the plea agreement, as being excluded as a form of punishment. It was the belief of the parties that any sentence imposed on Mr. Foley would be strictly only imposed by Your Honor and not by any additional collateral consequences, such as this citizen petition to have Mr. Foley be removed as Clerk of Courts. That petition is now pending. That would severely prejudice him if he is removed from being the Clerk of Courts. As a result of this plea, it would have been an unintended consequence of the plea agreement. It would be a breach of the plea agreement, and that is why we're asking that the plea be withdrawn at this time, Your Honor.
So the prejudice is having to face the litigation?
The prejudice would be the removal of Mr. Foley from Clerk of Courts, both dealing with the litigation of him being removed while this plea is still, while the sentence has been imposed. That's one form of prejudice. The other is that if
But that hasn't happened, so there is no prejudice.
But it's forthcoming at this time,
It's
Your
a
Honor.
foregone conclusion you can't reach. The Court of Appeals would make that decision in the future. So is it your position there's no prejudice right now?
It's not our position that there's no prejudice, Your Honor, because as the current plea sits right now, it is considered to be a disqualifying offense under the present statute. And so as a result of that, it would rule Mr. Foley to be excluded from being Clerk of Courts, which was an unintended consequence.
So it's a foregone conclusion? The Court of Appeals action is a foregone conclusion?
Your Honor, the charge in which the plea was made to, by agreement of the parties, in the understanding of the state of Ohio and the defense, would not be an offense. It would, in any interpretation, cause Mr. Foley to be possibly lose his job. It's clear that the charge, this one charge that the state chose and represented, that would not face any type of disqualification, is a charge that could be seen as one that's a disqualifier. And I think it was by design that we're trying to avoid this, and by design it has failed. And so he's facing the removal is a consequence, and by legal design it is completely not what was agreed to. And for those reasons, I think it's clear that the prejudice has occurred now, and if we wait for a ruling, then I think that we have a damage that can't be fixed at that point. And the harm to Mr. Foley would be completely in violation of this agreement that was reached in good faith by the state of Ohio and the defense. And we spent time trying to find a way to do this that had a certain result, and it seems as if that result's not.
Yeah, but you switched to a different theory. Like, I don't disagree with the contractual representations. That's your strongest argument. It was a material condition.
Right.
But my questions with regard to prejudice are a whole different line of reasoning, because the prejudice analysis isn't the contract analysis. It's the criminal law rule 11 analysis. there's more than one way to get you where you need to go. I'm supposed to consider all of them and decide what the theory is. Oh, by the way, I get my papers graded by the same people that you're concerned about with the action up in the Court of Appeals. It's how the structure works. So I can't just like analyze this in one respect. I need to be thorough. So that's why I'm punching you on the prejudice side of the case, not the contract side of the case. So, I mean, you can sit down, you don't have to lean in. But I get what you're doing. You just switch gears on me. There's different theories of how to get you where you want to go. When, in fairness to everybody, the discussion, the context for the plea was greater concern with the Ohio Ethics Commission. That's where most of the focus of your informal conversations were, is what's the likelihood, what's the tolerance, what's the disqualifying offenses, what's the tracking history of that board in these cases. So like that was sort of the context. Nobody really anticipated that there'd be an independent taxpayer action, which is completely appropriate under 2733. So if we overlook something, that happens. Do you want to jump in here, Mr. Anger?
I don't have too much to add. I think that there was kind of mutual understanding, and through further research, we have discovered that the statutes aren't as clear as we had hoped. And as Mr. Ryan was saying, we're an effort to weigh all the strengths and weaknesses of each case, as the state always does, and come to a proper resolution. The state's interest is making sure that resolution is sound. And if it's not going to be, then that's something we should address.
Fair enough. So just as a matter of education, this is like probably talking to the public, but the criminal justice system moves along by 97% of its cases being resolved by agreements. Sometimes a plea to the indictment, sometimes a mutually recognized sentence, sometimes a plea with nothing agreed, but the case authority acknowledges that, coaches the courts to not interfere because it's a matter of contract. So that's the strongest argument for the defense, and you don't oppose that for those very reasons. But like I'm supposed to keep in mind the big perspective is to give the parties what they bargained for. And there's this other test about setting aside pleas pre-sentencing as opposed to setting them aside post-sentencing, and having remorse be a factor which I don't see coming in here. So to the extent that there was a mistake of fact, I understand that. I understand you're not opposed. The question is whether the defense then understands that you get your whole indictment back, because part of the consideration was you negotiated away all the other charges. I can look up the math, but there was a dozen charges that you negotiated away when he pled to 2. So in giving the defendant what he wants, if that in fact happens, you then also get put back to where you were, and that's a full indictment, nothing less, nothing more, right?
That's my understanding.
Yeah, so when there's a benefit to the defense, there's no subsequent loss because you tried to enter into a negotiation. Right. So that's your understanding also?
Yes.
Right? Ms.
Yes,
Jackson,
sir.
Mr. Rowe? So essentially we just go back and hit the reset button and have a do-over, right? Okay, I have my punch list back in my briefcase. I'm going to go back and give some consideration to it, and then I can sort it out. I mean, there has to be a written decision because the Court of Appeals isn't going to want to see a transcript. They're probably going to expect to see a hard paper decision. What's the findings? So I'm going to go back and work on that. So we can go ahead and go off the record, and we'll issue a written decision. Thank you to the lawyers. That's all we have. Thank you. Oh, no, we don't. Hit that record again, would you?
Yes.
There was a motion, I think your motion to withdraw was found under seal, Mr. Ryan, or if I looked at it on the docket last night, it was too quick for me to pay attention. But is there any reason that that motion should be sealed?
No.
Could you find the motion online? I'm talking to the public now.
No.
I think it's under seal, so I didn't find a reason, so I'll unseal that, because the public's entitled to know. I think it's a relatively short one paragraph page, but when it was filed that way, it didn't give any notice, it just gave a title. So I'll unseal that because I didn't see that there's any reason it couldn't be filed publicly.
No objection.
Okay, thank you. All right, thanks to the lawyers and the court staff.
All rise. Court's in recess.